Welcome to Questions That Matter. Today I will be talking about an opinion piece that I wrote with Prashanth Reddy called Supreme Overreach, which was published in the Economic Times, where we discuss what is the appropriate way of selecting judges to the office of judicial magistrate and civil judges in the country across states. Now, in May this year, the Supreme Court ruled that a practice requirement of at least 3 years is mandatory for lawyers seeking appointment to the office of the judicial magistrate and civil judges. Now, simply put, these lawyers will now have to demonstrate that they have practiced for at least 3 years before a court of law before they can write the qualifying exams for judicial services. Now, this decision was in stark contrast to Supreme Court's earlier ruling in 2002, where it had abolished this practice requirement. And as a consequence, we saw that across states, people in the age bracket of 21 to 27 years were being appointed as judges to these offices. These offices are of immediate importance to ordinary citizens. Under the Constitution, the police is required to produce a person they have arrested before a judicial magistrate who decides whether that person should be remanded to police custody or granted bail. Similarly, the civil judge has a wide civil jurisdiction based on the valuation of the suit. They decide important contractual disputes. They decide whether a stay injunction should be granted to someone whose house is being demolished. Now, why is this important? Given that a lawyer who is 3 years into practice, it's very difficult to imagine that they would have conducted a single trial or would have cross-examined a witness. In our opinion, a 3-year practice requirement is not sufficient to gain any meaningful experience at the bar, and the court does not really demonstrate whether 3 years is enough. Now, in the Constitution, it is mandated that advocates who have at least 10 years of practice requirement, only those advocates can be appointed to High Court judgeships. Similarly, for the district judge, the Constitution prescribes a 7-year practice requirement. In practice, in fact, it's very unlikely that people younger than 45 years are appointed to these judicial offices. Now, we think that it is in fact time to question the basis for prescribing different practice requirements for judicial offices depending on the location of the office within the judicial hierarchy. By no means are the functions performed by a judicial magistrate or a civil judge easy, and therefore we do insist that a practice requirement of 3 years is just not sufficient to be appointed to these offices. Secondly, the Supreme Court relied on very thin evidence. Mostly it was complaints aired by high courts saying that these young judicial officers are not up to the task. Similarly, there were several complaints by the bar, but there was never really an empirical study carried out by the Supreme Court to justify why it was now imposing a 3-year practice requirement. The last thing that we do want to tackle is to argue that the Supreme Court was not really deciding on any question of law. Now, whether or not a person should have a certain years of practice before they have been appointed to the post of the civil judge or a judicial magistrate is a question of policy, not of law. And therefore, courtrooms are terribly unsuitable for deciding questions of policy. Additionally, the Supreme Court has no business deciding this issue. Constitutionally, it should be the state governments in conjunction with the high courts which should be deciding this issue. The other problem with having policy matters being decided by the Supreme Court is that the discussion remains confined to the issues framed by the court. It is not really suitable to decide policy questions in that manner because they have far-reaching and long-term effects. It is really important that we pay attention to the experience and qualifications of persons who are being appointed as judicial magistrates and civil judges across the states because they discharge very important functions. And in our opinion, it has been argued that this might distance women and other persons from marginalized identities from assuming these offices. But the larger question to worry about is why is the bar not friendly to persons belonging to certain gender and caste identities? And perhaps the reforms that are needed in litigation are more important than to make sure that we ease requirements of practice for judicial offices. Now, such matters of judicial policy are routinely litigated before the Supreme Court, and the Supreme Court is just not the appropriate site for such judicial policy making. It is in defiance of the constitutional mandate, which allocates these tasks to the state governments and the high courts. And the Supreme Court has also been consistently missing the mark on these issues. If you want to know more about the work that we are doing at TrustBridge, please like and subscribe our channel, TrustBridge Rule of Law Foundation, for more such videos. Thank you.